Yes.
My lord, I am appearing on behalf of the appellants, my lord. This is the appeal by the defendant. Second appeal, my lord. The plaintiff filed the suit decreed, and thereafter appeal preferred by the defendant dismissed. Therefore, my lord, the defendants are before my loss. Now, my lord,
Declaration of right title in
yes, my
possession.
lord. Yes. If my lord, make for a moment, may kindly see the decree of the trial court. The prayer of the
Yes.
plaintiff is there, my lord. I am reading
Yes.
the prayer. What were the prayer? For that, it be declared that the defendant number 1 and 2 have no right and title over the Schedule A land, and they are
What are
not
you reading?
Manas.
For that be declared that the plaintiff have valid right title over the scheduled land A property.
Yes, Manas.
For
Manas,
that be decreed that the defendant number 1 and 2 have no right title over the scheduled A land and they are not in possession of the suit and the defendant have no right to interfere with the position of the plaintiff.
Manas. Then, Manas, for that the defendant be permanently injected from going upon the Schedule A land and unnecessary interference with the possession of the plaintiff regarding the suit land. And now, my lord, fourth, if for a moment, my kindly see that is very important, my lord. For that, in pendency of the suit, if the plaintiff are found to be dispossessed from the suit land, that is Schedule A, then khas possession be given to the plaintiff by the process of the court. So these are the four prayer made
Clear.
by the plaintiff, my lords. Now
Okay.
the learned court has said that let this suit be and the same is decreed on contest with cost. Now fact of this case is, my lord, the defendants are the descendants of Thakuri Ganju and Sahiba Ganju, who are the original recorded tenant. This is admitted position.
The plaintiff,
The defendant.
the defendant.
Yes, my lords. Now the case of the plaintiff is that these defendants who
Read
are
from paragraph 2. Read from paragraph 2.
Madam. The case of the plaintiff in short is that the plaintiff are the settled occupancy rayat of village Masaratu police station Katkam Sandhi district Hazaribagh. The suit property fully described at the foot of the plaint in schedule A may be treated as and forms its part. Genealogical table of the plaintiff more fully described in schedule B be treated as part of the plaint. For realization of rent from the Rayas, the ex-landlord through his manager Ramgarh Watts estate filed certificate case bearing number so and so against Thakuri Ganju and Sahiba Ganju before certificate officer Hazaribagh, in which the entire land of Khata number 30, total area 10.7 acres, situated in village Chichi, Thana number 101, police station Hazaribagh, the schedule A was auctioned on 23/3/1935 and the manager Cooperative Bank Limited Hazaribagh purchased the entire land of Khata number 30, an area of 10.7 acres of village Chichi, Thana number 101, police station Hazaribagh, and accordingly thereafter sale certificate was signed on 12/7/1935 by certificate officer Hazaribagh. The manager Cooperative Bank Limited Hazaribagh for taking delivery of possession from the recorded tenant filed a case bearing number so and so before the certificate officer Hazaribagh, and accordingly the possession of the land was delivered on 2/7/1936. The manager Cooperative Bank Limited, after delivery of possession, came in physical possession over the land of Khata number 30 of village Chichi, Thana number 101.
You are the
No,
uh,
from this, my lord, thereafter they say, then
no,
again
just
this,
a minute. Who are you?
I am the successors of original recorded tenant,
Mane
Sahiba Ganju.
Thakuri Ganju and Shaiba Ganju.
Yes, my lord.
Okay, then go on. Go on reading.
The Hazaribagh, and accordingly the possession of the land was delivered on 2/7/1936. The manager Cooperative Bank Limited, after delivery of possession, came in physical possession over the land of Khata number 30 of village Chichi, Thana number 101, police station Hazaribagh, with the knowledge of the entire village, including the ancestor of the defendant, and was enjoying the usufruct thereof without any let or hindrance. The manager, Central Cooperative Bank Hazaribagh, was also negligent in paying the rent to ex-landlord. Hence, the ex-landlord, through its manager Ramgarh Ward Estate, filed certificate case number 132/1937-38 with respect of land under Khata number 30, area 10.7 acres of village Chichi, Thana number so and so, police station Hazaribagh. The Schedule A land was auctioned on 3rd day of January 1938. On 3/1/1938, the common ancestor of the plaintiff, namely Pandit Divakar Sharma, along with one Hulas Mato, jointly purchased the Schedule A land in auction sale. The sale certificate was sealed and signed by Certificate Officer Hazaribagh on 30th day of March 1938 by confirming the title and possession of the above named purchaser by the Certificate Officer Hazaribagh, and accordingly the auction purchaser above named came in physical and cultivating possession over the Schedule A land without any hindrance, with the knowledge of the entire villagers, including the ancestors of the defendants. The ancestor of the defendant Thakri Singh, Sahib Singh, or his sons Charka Ganju and Mohan Ganju never raised any objection, even they have not filed any case against the auction sale in any competent court regarding the Schedule A land. Hence, the certificate case number so and so and certificate case number so and so, as well as the delivery of possession by case number so and so, become absolute, and now the defendant are ousted from the suit land mentioned in Schedule A of the plaint from 2/7/1936 by the order of the Certificate Officer Hazaribagh. Hulas Mato later on executed a deed of gift on 10/3/1939 in favor of the Pandit Divakar Sharma and gifted his entire share of land of Khata number 30. And after receiving deed of gift, Pandit Divakar Sharma became absolute owner of the Khata number 30, an area 10.7 acres, that is Schedule A land, and came in cultivating possession over the suit land till he remained alive without any let or hindrance. Pandit Divakar Sharma was paying rent to the ex-landlord. On the petition of Pandit Divakar Sharma, the rent of Khata number 30 was reduced by case number 705 dated 18/9/39. After vesting of Jamindari in the state of Bihar, the name of Pandit Divakar Sharma was entered in Register 2 and was paying rent to the state of Bihar, now the state of Jharkhand. After death of Pandit Divakar Sharma, his two sons, namely Baikunt Sharma and Bholanath Pandey, jointly inherited and came in possession over the Schedule A land. But soon after the death of Pandit Divakar Sharma, his two sons partitioned the entire land acquired by the Pandit Divakar Sharma, and Schedule A land came in share of plaintiff. And land situated in village Khambwa, Tola Churhu, Thana number so and so, Bisungarh in Khata number 9, an area of 1.26 acres, and in same village, that is Khambwa, Tola Churhu, Thana number 158 PS Bisungarh in Khata number 5, an area 5.52 into half acres, and in same village in Khata number 5, an area 4.4 acres, 14 acres. Land goes in the share of Bholanath Pandey. Hence, on the basis of partition, the plaintiff number 1 became absolute owner of Schedule A land and are in cultivating possession over the same without any hindrance, with the knowledge of the entire villagers, including the defendant, and are paying rent to the state. Like each and every year, the plaintiff plot the Schedule A land and grown paddy crops, and the plaintiff used to go in Schedule A land to look after the paddy crops grown by them. The defendant number 1 and 2, who have had no right, title, interest upon the Schedule A land, with the help of defendant number 3 to 6, another anti-social element, started disturbance and raised his claim for the first time on 22nd/10/2003 on the basis of Khatian, when the plaintiff were standing in the Schedule A land, and threatened the plaintiff that if they try to come against Schedule A land, then they will be killed. The plaintiff are still in cultivating possession over the Schedule A land and are paying the rent to the state. Nowadays, there is no existence of entry of name in Khatian regarding Khata number 30, that is Schedule A land, since the entire land of Khata number 30 was auctioned sold by the order of the Certificate Officer Hazaribagh, and hence, as per Khatian, the descendants of recorded tenant cannot be entitled to claim Schedule A land. The plaintiff, to protect his life, want to take the shelter of police against the threatening given by the defendant, but the concerned police has not taken any action. Hence, the plaintiffs filed the proceeding under section 144 CRPC bearing case number so and so, and other proceedings under 107 CRPC bearing case number so and so, filed on 1/11/2003 before Sub-Divisional Magistrate Hazaribagh. The learned Sub-Divisional Magistrate Hazaribagh, after hearing, has not drawn up proceeding under section 144 CRPC against the defendants. Hence, after lapse of 3.5 months, the case was withdrawn, since plaintiff have not been given justice at the hands of Sub-Divisional Magistrate Hazaribagh. The proceeding under Section 107 CRPC is still pending since the subdivisional magistrate Hazaribagh has not protected the right title of the plaintiffs, hence the plaintiff have been advised to file the suit. The cause of action of the suit within territorial jurisdiction. So the case of the plaintiff is that they have purchased the land from Manager Cooperative Bank Limited. And their case is that Manager Cooperative Bank Limited has purchased the auction sold property and they got the possession. The plaintiff has not stated that they also got the possession from this Manager Cooperative Bank Limited. Rather, they are relying upon the possession taken by.
No.
Manas.
Manager Cooperative Bank also failed to pay the rent, so the land was again auctioned. Then
Yes.
the father of the plaintiff took possession in the auction and the purchase
No,
in auction sale.
the exhibit what they got marked is that possession was firstly taken by the Manager Cooperative Bank,
Yes,
and
yes.
then
Thereafter
they purchased
again.
the property and they are in possession.
Thereafter.
Manas. Now the case of the defendant is that they have paid rent to the ex-landlord.
You denied auction, you denied everything.
We denied everything. So our
But
case is simple.
in case of it, there was auction. You cannot deny that fact.
Manas, this is my humble submission before this honorable court. So the simple case of defendant is this, that they were
It is not your case that even if there was an auction, the diverse possession, this auction was nothing. You denied auction. Then you say that the auction is a paper transaction. If there was
we said auction is paper, the possession from us was never taken under any proceeding. That delivery of possession was mere a paper transaction and we remain in our possession. Malak, so the defendant has set up a case of the adverse possession. Now, in my humble submission, Manas, if the defendant simply takes a plea that they are in adverse possession of the property, then it is incumbent upon the court below to consider as to when these defendants came in possession of the property, because I was reading the relief prayed for by the plaintiffs.
First of all, you need to plead adverse possession. You have to accept that you are not the title holder.
No, title Kua, the plaintiff.
Do you accept that you are not the title holder?
This is just my humble submission is, so far as plaintiff is concerned.
I am asking you a question. You have prayed for your own title. You say that I am the title holder.
Yes.
See, that way, so if this is your case, adverse possession, if this is your case, how can it be a positive case of adverse possession so far as you are?
Manas, this is what I am trying to persuade Manas.
Yes.
That my position is adverse Kua plaintiff because they are saying that they came in possession of the property, and I remain in the possession of the property.
Your property, see, adverse possession, your possession will be adverse towards the title holder.
Yes. Now they are coming with that they have purchased the property.
But you say that you are the title holder.
My submission.
Your case is that you are the title holder. So where is the question of adverse possession? Adverse possession. To claim adverse possession, you have to admit at one point of time that yes, I am not the title holder, but my title is adverse to him who is the title holder.
This is my submission before this honorable.
But it was not your case.
Once they say that they have purchased the property, at least from that day, my position Kua plaintiff becomes adverse, because plaintiff are claiming that they become the title holder of the property. So I remain in possession. So it is in their knowledge that they are in possession of the property. So my position is adverse.
Both the courts have held that you are not in possession.
This is what both the courts have not considered the point of possession. This is the case. Because the position can only be, this is, my lord, I am only reading the finding, 1 page of the trial court and 2 pages of the appellate court.
Yes.
If my lord may kindly see. If my lord may kindly come to page 13, internal page 13 of this judgment, my lord.
Yes.
I am reading from the second line, my lord. Exhibit 3235 are the government rent receipts which also stand in the name of Divakar Sharma for the lands of Khata number 30 of Moja Chichi, area 10.7 acres. On the other hand, the defendant have brought on record 4 Jamindari rent receipts which have been marked as Exhibit A283. These receipts appears to be created for the purpose of suit because the number of rent receipt is not printed, and apparently it appears that these rent receipts have been prepared in one sitting and writings are fresh. From the documentary evidence itself, it is quite clear that the defendants are claiming the lands only on the basis of entries made in Khatian, but they are not in possession of the land mentioned in Khatian because As per the documentary evidence brought on record by the plaintiff, the delivery of possession of the land of Khata number 30 was given to the auction purchaser, and these defendants have been ousted from the suit land from the time of their ancestors. So far as the oral evidence is concerned, according to plaintiff, the plaintiffs are in possession, and according to witness of the defendants are in possession over the suit land. So this is nothing but an oath against oath. It is settled principle of law when the case is proved only on the basis of documentary evidence, which is primary evidence. The secondary evidence, oral evidence, has no much more importance. Even then, I want to cite some statement which is enough to draw the conclusion to the plaintiff are in possession of the suit land. PW5, Baikunt Sharma has supported his case during examination in chief. He has admitted while para 22 of his cross-examination that he has filed the papers of delivery of possession. He has also stated while para 23 that a deed of gift was executed in favor of Divakar Sharma. He has stated while para 25 that mutation had taken place with respect to the lands mentioned in the deed gift. Of course, the mutation order has not been brought on record, but the current rent receipt subsequent to the deed of gift standing in the name of Divakar Sharma have been brought on record. The other witness, well, this witness has admitted in his evidence that there is a house standing of these defendants over the suit land. Of the plaintiffs have corroborated the statement of plaintiffs so far as the witness adduced on behalf of the defendant are concerned. They have also stated that defendants are in possession of the land, but their statement appears to be interested and not on the basis of any documentary proof. But without any basis, this is the court is saying. But all these witnesses produced by the defendant were the co-villagers of that village, whereas the plaintiff has brought the
Just
village.
answer one question.
Yes, Manas.
After the zamindari was abolished,
Manas.
is there any rent receipt in your favor?
No.
Finished.
Manas, what I am submitting is why I am arguing before this honorable court. If my lordship may allow me to read one order of the learned court below itself.
Yes.
Because my lord, I am only saying the last prayer of the plaintiff, because it has been held in both the case that the suit and the suit is hereby decreed. Both the courts has held that the plaintiff has title and possession over the suit property. Now I am only reading, my lord, they have filed one application under order 39 rule 1 and 2. Then my lord, I will make my submissions. I am only reading the, my lord, few paras of that order, my lord. If lordship may allow me. No, defendants are claiming. I am reading the order of the court, my lord.
Mr. Tiwari.
Defendants are claiming
Mr.
that they
Tiwari.
Mr. Manas.
Mr. Tiwari.
Manas.
Seeing you are standing at the bar,
Manas.
that you as a civil lawyer,
Manas.
you are trying to impress upon an interlocutory order under order 39 wall and 2 when the suit has already been disposed of.
No, Manas, what I am trying to.
What findings and everything is passed in an order 39 1 and 2 is a prima facie finding. It has got nothing to do with the final order.
No, my submission is, my lord.
I didn't expect this from you.
No, I am only, no, Manas, I am not reading that particular thing. My lord, might kindly see the issue framed by the learned court. My submission is, at least if they are claiming that they are in possession of the property, then delivery of possession should not be given to the parties. If the honorable court comes to the finding. Otherwise, if the honorable court comes to the finding that the
rent, a rent is received from whom? State receives the rent from whom?
The plaintiff has filed the rent receipt.
No, just. What is the value of a rent receipt?
That is presumption, Malas. They
are presumption of
possession.
Finished.
My submission. Only last prayer I am submitting, Malas.
Yes.
Whether once the court comes to a conclusion that plaintiffs are in possession of the property, can the plaintiff entitled for a relief of recovery of possession?
It's an alternative prayer. Dismissed.
Serial number 38, second appeal 277 of 16, Mr. Vinod Kumar Dubey, Mr. Naveen Kumar, Mr. Gopinath Chandra, Mr. Ravi Prajapati, Mr. Abhishek Kumar, Order.
Mr. Vishal Tiwari will assist, Your Lordship. Mr. Vishal Tiwari will assist.
Yes.
May I pray, Your Lordship? I'll be assisting my lord.
Yes.
This is Lordship. The plaintiffs are the appellant, Lordship.
Yes.
Plaintiff, appellant, Lordship. The
Title suit.
second appeal, Lordship, is against the affirmance. The
Yes.
prayer, Lordship, was the plaintiff in the plaint was for declaration of right title and interest, as well as for confirmation of possession. That was the first prayer, Lordship. And the second prayer was for declaration of the three sale deeds as illegal and void and without consideration. Now, Lordship, if Lordship permits me, I'll just be giving a brief background of the case, Lordship. In this case, Lordship, it is an admitted fact that the four persons, Pagna Bhuya, Bhagna Bhuya, Magna Bhuya, and Jagna Bhuya, all the four persons were the recorded tenants. And Lordship, the property was about 65 decimals of land of village Gobar Bandha in Khata number 15, Lordship. That is the main contention of this case, Lordship. Now, one striking point is here, Lordship, is that all the defendants, Lordship, who has contested the suit are all the purchasers. Like Lordship, like the plaintiffs also. The plaintiff is also a purchaser from the all the four persons. One of the four persons and other defendants who are contesting the suit are also the purchasers, Lordship. Only one defendant, Lordship, that is defendant number 7, who happens to be the Chakkan Bhuya, the son of Manu Bhuya, from one of the recorded tenants, descendant of one of the recorded tenants, has come with an written statement, and who is my vendor, Lordship. Now, Lordship, if allows me, I'll just briefly read the plaintiff's case, Lordship.
Yes.
That the lands of Khata, from the trial court judgment, Lordship.
Yes.
Lordship. From the lands of Khata number 15, village Gobar Bandha, Thana number 32, PS such and such, district Hazaribagh, is recorded in the name of Bhagna Bhuya, Bhagna Bhuya, Magna Bhuya, and Jagna Bhuya, sons of Bandhan Bhuya. A genealogy of the recorded tenant has been given in Schedule C of the plaint. There was a partition among the four co-sharers, each getting the share after partition. Bhagna Bhuya and Jagna, Lordship, Jagna is wrongly been written. It is Bhagna. I have corrected from the plaint itself, Lordship. Bhagna Bhuya formed a reunion and reunited their properties in between them. Bhagna Bhuya had no issues. His wife had predeceased him. Manu Bhuya performed the Agni Sanskar. Bhagna Bhuya and Manu Bhuya cultivated the lands of Bhagna Bhuya and also maintained and nursed him throughout his life, and after his death, his last rites were done by Bhagna Bhuya and his son Manu Bhuya. The properties of Bhagna Bhuya was inherited by Bhagna Bhuya and Manu Bhuya, who remained in cultivating position exclusively. Otherwise, also Bhagna Bhuya had executed an unregistered sale deed for consideration in favor of Manu Bhuya in the year 1929 for the lands of 16 decimals out of Khata number 15. In this way, Bhagna Bhuya and Manu Bhuya became Rayat over the half share of the land of Khata number 15. Bhagna Bhuya and one son Manu Bhuya had a daughter Jamuni. Manu Bhuya died leaving behind his son Chakkan Bhuya. He is Lordship the defendant number 7, Lordship. Jamuni was wedded to Jagannath Bhuya and she died about 40 years ago without any issue. Jagannath Bhuya got another wife. She was also named as Jamni Devi, but she was not the daughter of Bhagna Bhuya. It has been further been averred that in the plaint that out of area of 65 acres of land of Khata, 65 decimals of the land of Khata number 15, Bhagna Bhuya and Manu Bhuya had become Rayat over 32.5 decimals of land. Accordingly, a separate Jamabandi was opened in the name of Manu Bhuya. Manu Bhuya died in the year 1962, leaving behind his son Chakkan Bhuya. The daughter Jamnu Bhuya, who had married, had predeceased her father. The plaintiff further case is that they have purchased for consideration a land measuring about 10.5 decimals of the plot number 40 of Khata number 15 from Chakkan Bhuya, again defendant number 7, by registered sale deed number such and such, and came in possession of the land, which is Schedule A property. The plaintiff collected materials at the site for construction of the house, but defendant number 1, 2, and 4 with muscle men and began to throw the bricks and scattered the materials. Proceeding under section 144 CRPC was initiated and the SDM in wrong appreciation of the facts made the rule absolute against the plaintiff. In course of the proceeding, plaintiff came to know about the existence of the sale deed dated 1970 such and such. Land involved in the sale deeds are described in Schedule B of the plaint. The above sale deed included the entire land of Khata number 15. Although this is important, Lordship. Although the vendors, namely Janki Bhuiya, Prayag Bhuiya, Tilak Bhuiya, Mosamal such and such, Virasi together had not more than half lands of Khata number 15. Either the vendors were in possession of the entire area, nor the so-called purchasers came in possession over the whole of the area. It were the plaintiff and their vendors who were and are in possession of the lands. Jagdish Mato, Mahesh Mato, such and such, such and such, such and such, executed in respect of 4 dismills of land in plot number 40 by setting up persons by impersonation of Mosamad Jamuni by fraudulently showing her to be her daughter of Phagna Bhuiya. That the daughter of Phagna Bhuiya, namely Jamnu Bhuiya, died long back about 40 years ago. The husband Jagannath Bhuiya remarried with another lady who was also named Jamni, but she was not the daughter of Phagni Bhuiya, rather she is the daughter of the Jagat Bhuiya. It is Mosamad Bilasi who has
144 was in your favor.
No, Lordship, against mine. Therefore, Lordship, that was the cause of action. Therefore, I filed the suit.
You are the plaintiff.
I was the plaintiff, Lordship.
The 144 was against you.
Against. We had preferred filed an application before the SDM, but that was made absolute against us, Lordship, and that gave the cause of action for us for filing this suit, Lordship. Now, Lordship, I'm just pausing for a moment here. My case is that, Lordship, a very simple case. It is not in dispute that the 4 persons were there, recorded tenant. I had purchased only 10.5 dismills of land. I am one of the purchasers in the as a plaintiff, Lordship. And Lordship, even dividing the shares of to all the 4 brothers, Lordship, it is coming around 16.5 dismills for all the brothers, Lordship. I have
What is the total extent of land?
65 dismills, Lordship.
Okay.
And now, Lordship, what the defendant number 5 is saying, the deed of 1970, I am not concerned with that deed, though I have prayed for that. But Lordship, admittedly, Lordship, the defendant number 5 has said that she has purchased the entire land of 65 dismills by only 2 brothers.
Which cannot be
accepted.
Yes.
Though Bhai Huzur, after 4 brothers, 2 brothers have executed, the descendants of the 2 brothers have executed the entire 65 dismills of land.
That sale deed is there.
That is there, Lordship.
That is there on record.
Therefore, Lordship, whatever share they will get out of the share of the only 2 brothers. That is around 32.5 dismills of land. My contention is there, since I have purchased only 10.5 dismills of land from one of the descendants of Phagna Bhuiya, and he was the only one person there alive. Therefore, that was to be given to me, Lordship. I am only for that purpose. And since, Lordship, both the courts below have erroneously considered whimsical manner the things which are not required to be expressed in this case, Lordship, those things has been considered. I am not saying anything about reunion. What they have said, the reunion.
No, you have prayed for declaration that the sale deed of 1970 in favor of Mathura Prasad.
That is one of my prayer, Lordship. Yes.
Sale deed number in favor of Subha Devi and sale deed number so and so in favor of Jagdish.
That is my second prayer, Lordship. My first prayer is that right title and interest, so far as my purchased property is concerned, for 10.5 dismills, that may be declared. The court could have.
You purchased from whom?
Lordship, we purchased, Lordship, from the descendants of Phagna Bhuiya. The defendant number 7, Lordship, who is
respondent defendant number 5 purchased from whom?
From, Lordship, the other two brothers, Lordship. There were 4 brothers, Lordship. From one brother, I purchased 10.5 dismills.
Whose document is prior?
The document, Lordship, of 1970 is, of course, prior to my document. But, yes, Lordship, that is with regard to the share which they do not possess. That can only be acted upon on the half share of the 2 brothers. That is my contention. It was a very simple case.
How do you say so?
Yes, Lordship, it is come in the finding. That is the admitted fact. The defendant number 5, plaintiff, Lordship, I will be reading. They have admitted that they have purchased from two brothers. Entire property they have purchased. May I come to that, Lordship? That was a very simple.
Have you prayed for cancelling of that sale deed?
We have prayed, Lordship, but even if that prayer is not should not go in my favor, but Lordship, about the declaration of only 10 dismissals of land which we have rightly purchased, Lordship, that could have been given to me. A person who cannot give anything which does not possess. Their vendors of defendant number 5.
It's a joint property.
Lordship, joint property.
Then
the entire property cannot be sold by only 2 brothers.
How are you saying so?
Lordship.
How are you saying so?
Defendant number 5, Lordship, their admitted fact, Lordship. They have stated, Lordship, in their deposition, in their statement, Lordship. That is that, Lordship, paragraph 4.
What is the right of a co-sharer?
Co-sharer, Lordship, inherits as per his own share.
It is an undivided share.
Undivided share, Lordship. But even if undivided share, the 2 brothers, even I am putting a question to myself. I being the one of the, not even the Karta, the 3rd brother of the family, can I sell entire property of my all the brothers?
No. Where is the question of Karta over here?
That is what I am saying, Lordship. The
This is
second,
not a
3rd, and 4th brother, Lordship, has sold.
It is simply it is a joint property.
Yes, Lordship.
It is a joint property, and you say it belongs to 4
All
persons.
the 4 brothers. Yes.
4 brothers jointly.
Joint.
Now, out of that, 2 persons sells the entire property.
Entire property, Lordship.
Now, I'm just putting a question.
Lordship.
Suppose if the other 2 brothers have relinquished their right over the property, then can't these 2 brothers sell the
It
entire
is
property?
not their case, Lordship. It is
No,
not their case.
I'm just asking you.
Yes, they can relinquish, Lordship. It should be a relinquishment. Deed should be there, Lordship. Paragraph 4, Lordship, specific reading is there on their behalf. If they have purchased entire 65 decimals of land, they might purchase. But the thing is that it cannot go more than 32.5 decimals.
Now, what is your finding about that cancellation of that deed?
Lordship, the deed, what they are saying, Lordship, I'm just coming to the findings also. The entire wrong consideration, Lordship, entire judgment is perverse, Lordship, and the appellate court judgment is also word to word same of the trial court judgment. If I'll come to the appellate court judgment, Lordship, that is properly written also. Lordship will kindly find from those things, Lordship, if Lordship permits. From internal page 8 of appellate court judgment, Lordship.
Let me call for the lower court records.
Lordship.
Call for the lower court records. Let me see the sale deed. It is on record.
Lordship. It is on the exhibited, Lordship.
Serial number 40, second appeal 280 of 16, Mr. Omkar Nath Tiwari, Mr. Gautam Rakesh, for the appellant, Mr. Suresh Kumar, Mr. Krishna Shankar, for the respondent.
May I pray for 1 week accommodation, Your Chief?
Mr. Omkar Nath Tiwari prays for a week's time in this case. Prayer allowed is this case after 1 week.
Lordship, for the state.
Okay, give your slip.
Probably.
Because the counsel for the state has got no objection to this, to his prayer.
List over.
Okay, thank you.